On this episode of Law Weekly, we continue our series on electoral jurisprudence, where a senior advocate of Nigeria, Dr. Remi Olatubora, talks about the justice system and its impact in promoting peace in the society. Also on the program, we take a look at the 2023 Judges Conference, where President Bola Tinubu calls for strengthening of the rule of law. We'll also hear from Rivers State, where the state governor, Siminalayi Fubara, and other legal practitioners tasked judges on effective justice delivery. And in Edo State, the Labour Party believes the rule of law will prevail in the Edo Local Government Election Tribunal. Plus, a recap of the trending stories from the courtroom. Hello and welcome to the program. I'm Millicent Walker. Last week, we began a series on electoral jurisprudence and its effect on the nation's legal system. Now, here's another interrogation on the issue with a senior advocate of Nigeria. Take a look. Thank you so much for talking to us today.
Nice having you around in my office.
Our electoral jurisprudence, how does it come across to you vis-a-vis our democracy?
We are not getting the result that is desirable, in the sense that virtually all election contests in this country ends up in the courtroom. It shouldn't be. Elections as basic as party primaries end up in court. It isn't good for our system. In the last round of primary elections, over 1,000 civil actions were filed at the Federal High Court. And that bogged down the court for over 6 months. The Federal High Court is essentially a revenue court. It shouldn't be bogged down by electoral matters. And immediately after the election also, so many cases were thrown up. In respect of a particular election in one of the southeastern states, there were 8 election petitions filed by different parties. That's not good for our system. So ultimately, what happens now is that it is the court that decide on who ultimately occupies a particular position.
So where do you put the problem? Is it with the lawyers, the politicians, the judges?
The judges do not invent cases. It is the politician. The politicians are the ones that file cases. They are the ones that become dissatisfied with the result of elections. And the blame cannot be put on the politicians alone. The system of law that we operate also is a big challenge. The institution of the Independent National Electoral Commission also is one of the challenges that we are facing. I was part of the 2014 Constitutional Conference. We recommended that INEC as it is should be broken into 3 organizations. Why INEC proper should be charged with the conduct of election itself, there must be an agency that is responsible for the prosecution of electoral offenses. The system as it is now, INEC is bogged down by too many activities and functions such that they could not provide effective monitoring for elections. Even during the off-cycle election that have just been concluded, you still find that there are challenges that INEC itself could not cope with. INEC, for example, cannot even control some of their workers. The ad hoc staff that they employ are not essentially their employee. Many of them are members of the National Youth Service Corps or scheme. So they are not directly under the employment of INEC. So there's a level to which INEC itself can exercise control over them. As the law stands at the moment, the onus is on the petitioner to prove that he alleges in his petition If, for example, he alleges that there was non-compliance in the conduct of election, that is non-compliance with electoral law, he must prove the non-compliance or compliance polling unit by polling unit. And that requires that he must source his witnesses from a tribe of witnesses, outside of which he cannot put forward any competent witnesses. And this tribe of witnesses are the polling unit agents, or the presiding officer, or the poll clerk, or a voter who turned up to vote but could not vote, or who voted, as the case may be, depending on the kind of complaint. This is the tribe of witnesses that you should rely upon. And you ask from me, in a presidential election, for example, where the complaint is against what happened in over 5,000 polling units, and you agree to prove your petition in 5 days. Even in some cases, they also agree to streamline their witnesses. You agree, okay, I'll call 200. At that point, you have lost that case. Because the law as it stands requires that a petitioner must prove its case, you polling unit by polling unit. So if your complaint is against 10,000 and you agree to 5 days or 6 days, and then you agree to 200 witnesses, you have lost the case. Because the law requires you to bring one of the individuals I've mentioned earlier who will give oral evidence and tender in evidence the document used for the election.
A senior lawyer had suggested that the onus be on the winner to prove that he won that election. Shouldn't we consider that? Also consider giving INEC some burden of proving that they conducted an election of repute?
That is an untested jurisprudence, because, you know, we operate what we call the adversarial system of justice here, where an individual, they call the claimants, make adverse claim against the defendant, and the defendant also put up his own defense. The law as it stands at the moment requires that the claimant should prove his case. In election petition, the onus is on the petitioner. This idea of shifting the onus to INEC is a novel one that has not been tested. But I would recommend, for instance, that we do what the English lawyers did when the rules against hearsay evidence became very problematic in the administration of justice. They tinker with the rule against hearsay evidence. We can also tinker with the rule against hearsay evidence. If, for instance, I as a petitioner put in evidence a form EC8A, that is the result of a polling unit, and on the face of that document, we find that whereas 300 voters were stated to have been accredited, the total vote return is 400. On the face of that document, the judge should be allowed to make a conclusion that is a proven case of malpractice. But if we insist, as the law appears to be at the moment, that even that which is apparent on the face of the document still needs to be proven by oral evidence of the party agent or the presiding officer, and the tendering of that document in evidence, the form EC8A, then of course we go nowhere. So the English lawyers tinker with the rule against hearsay by making hearsay evidence admissible, but giving the responsibility of the person who is going to call hearsay evidence to give a month's notice to the man on the other side. And look, I'm coming with hearsay evidence. If you want the person who is the author of that particular statement or document, within 1 month of that notice, you should be at liberty to invite him. But as it is, I do not think that his presence is required. That's what is obtainable under English law at the moment. So we should also tinker with our rules again. The rules that we have in our section 37, 38 of the Evidence Act should be tinkered with, particularly as they apply to electoral matter, such that we have gone halfway to that in the current section 137 of the Electoral Act, which requires that when particular non-compliance is apparent on the face of a document, it's manifestly disclosed, that's the language of the Act, in the face of a document, then of course the judge can dispense with oral evidence. But it appears from this last cycle of election decisions that there hasn't been a consensus of judicial opinion on how far this has gone to alter the existing position of the law, in which the court demand that electoral non-compliance must be proved by oral evidence and also through the changing of the document in dispute by the maker of the document.
Is there a place that electoral jurisprudence meets democracy and rule of law?
I think we should address all the facets of our electoral system. Let's improve upon the system we have at the present for the conduct of election. Let us leverage on the use of technology to ensure that we have credible election.
But we use BVAS.
But there are still complaints about the use of all of this, because we also don't have control over the providers of GSM services. Because the truth of the matter today is that we don't have electricity in many of our communities. And all this technology employed by INEC is dependent on electricity. Some of these BVAS machines, by the time they get to the rural area where they're to be used, require to be recharged. No electricity. And so, it's a whole lot of problem. The use of technology will assist us down the road in ensuring that we have credible election. All of us will carry smartphone, and the level of penetration of use of smartphone all over this country is so great that we can leverage on it. NBA elections in the last few years have been done on our phones. There have been challenges as to the credibility, but over the years also, the NBA has been able to work on it. So we can leverage on existing technology to power this way we conduct our election. If we have credible elections, there will be less litigation, and there will be less reliance on judges to determine who is going to be senator, or who is going to be governor, and who is going to be president, as we have at the moment.
One question I'm going to ask is, do you expect them to make an amendment such that elections and court cases will be concluded before swearing in?
I absolutely agree that we should have a system in which post-election disputes are concluded before new political leaders are sworn into their offices. But we must not only focus on post-election adjudication. We must also focus on reform that address the conduct of election itself. So, what I mean is that the reform in the electoral sector must be multifaceted. We look at the upstream part of it, preparation towards election, registration of voter, liberalizing registration of voter, bringing it as many people as are qualified to vote in this country into the net of register of voters, and then make distribution of PVC easier. And then we must also have a system of election that will address the problem we have with INEC at the moment. INEC seems to be broke down by a lot of activities. We recommended in the 2014 confab that INEC should be broken into 3 organizations. One organization must be in charge of registration and control and monitoring of political parties and their activities. One agency must be in charge of prosecution of electoral offences, because there are a lot of electoral offences that are committed. And if those who committed those offences have been made to face justice, that will have served as deterrent. But there's so much impunity in the electoral system. So if we have an agency that's dedicated to that process, then of course the situation will be better. Then you now have INEC as it is, focused to conduct of election itself. The reform, like I said earlier, must address all of these issues that are related to election. We should not focus only on post-election dispute, which is just an aspect of the entire issues that we have.
Welcome back. Now let's head to a conference for judges of the Superior Court, an event that all justices look forward to, as it gives them the avenue to discuss issues bordering on the judiciary while seeking solutions. At this year's event, President Bola Tinubu asked that the appointment of private legal practitioners to the Court of Appeal be considered as a means of strengthening the rule of law in the country.
Judges across all cadres of the judiciary across the country have gathered for this year's All Nigerian Judges Conference. The theme of this year's conference is strengthening judicial commitments to the rule of law and democracy, and it's designed to look into issues that have bedeviled the sector and prefer lasting solutions where necessary.
It is therefore my belief that acting in accordance with the themes of this conference, which is strengthening judicial commitments to the rule of law and democracy, this engagement will afford the lordship the opportunity to research, to collaborate and synthesize.
The Attorney General of the Federation represents President Bola Tinubu at the conference. He calls for the strengthening of the rule of law.
Under my leadership is our commitment to drive the judicial reforms to achieve sustainable socio-economic growth and investment. In view of the fact that the judiciary is largely self-regulating through the National Judicial Council, we expect the judiciary to demonstrate that charity indeed begins at home. Like Caesar's wife, the judiciary must be above board, always to retain public confidence without pandering to manipulated public sentiments.
The Chief Justice of Nigeria, Justice Olukayode Ariwola, charges the judicial officers to work assiduously towards sustaining public confidence and trust reposed in the judiciary.
As judicial officers, it is imperative that we constantly strive to attain a high standard of excellence and ensure that the strength of our character is at best unimpeccable. One fact which is glaring but ironically overlooked is the fact that judges are human too. Consequently, as we take stock, it is of utmost importance that we do so dispassionately and objectively to enable us effectively achieve the second purpose of the conference, which entails mapping out strategies, cross-fertilizing ideas, and eliciting definitive decisions necessary for steering the judiciary forward in the coming year.
The 5-day conference, which has officials from various arms of government, is expected to tackle challenges such as lack of transparency, accountability, inadequate welfare of judicial officers, among other issues.
Next, we move to River State, where the judiciary held its 2023-2024 legal year with a call to the bar and bench to strictly abide by the code of conduct of the legal profession and restore the confidence of the people in the face of growing concerns on that arm of government.
In the course of my address during the opening of the last legal year, I did mention that the High Court Rules Committee had been inaugurated to review the High Court Civil Procedure Rule 2010 of River State. It is my pleasure to report that the review was concluded, and after a colloquium, the new High Court Civil Procedure Rule 2023 was formally presented to the bar, bench and other stakeholders, and it took effect for the 3rd of April 2023. We now have 12 judicial divisions of the High Court, Rivers State. Secret to the volume of cases emanating from Emoha local government area and East Environs within Ishokpo Judicial Division, His Excellency Chief Inyesom Ezeonwike, CON, GSSRS, the immediate past governor of Rivers State, signed an instrument creating the Emoha Judicial Division on the 1st of February 2023. The foundation laying ceremony was held on the 14th of September 2023. It is hoped that within this legal year, the complex will be completed as promised by the chairman and handed over to the judiciary.
Over the last 8 years, the immediate past governor, my predecessor, His Excellency Onyesom Ezeonwike, now Minister of the Federal Capital Territory, gave attention to the judiciary and achieved so much in repositioning the state's judicial system. However, we must also admit that our judiciary has not yet reached the point of self-actualization. I wish to assure you of my commitment as the head of the executive arm of our government to provide tangible support in creating a sustainable environment to secure effective judicial independence and the efficiency in justice delivery in our dear states.
And thank you for staying tuned. In Benin City, the Labour Party filed 18 petitions against the outcome of the September 2nd local government elections in the state. A governorship aspirant in the party and former NBA president who was in court is hopeful that the tribunal will deliver justice in the petitions.
We were a little bit concerned initially. They had some teething issues, but the tribunal is in full swing. Rule of law prevails in Nigeria, in spite of what some may would prefer. Some prefer anarchy. Some prefer rule of the mighty. But the rule of law prevails in Nigeria, and it is that confidence that the Labour Party has, which is why we have brought our matter to the tribunal. And I'm happy. I see a 3-man panel, and they are going through. You know that the Labour Party has filed 18 petitions from all the local governments, and it has been a very rigorous process. And I see that the tribunal are up to the task, and they want to take each one, and they're providing, as far as I can see, a level playing field for all the parties.
Now to some of the stories that made the rounds this week in the courtrooms.
The appeal court sitting in Abuja has nullified the election of Governor Caleb Mutfwang of Plateau State. The 3-member panel, in a unanimous decision, also ordered the Independent National Electoral Commission (INEC) to withdraw the certificate of return issued to Mr. Mutfwang and issue same to the candidate of the All Progressives Congress (APC), Mr. Nentawe Goshwe. Delivering the lead judgment, Justice Elfrida Williams Daudu noted that under Section 134, subsection C of the Electoral Act and Section 177 of the 1999 Constitution as amended, it is the sole right of a political party to sponsor its candidate, having met the necessary requirements to do so. Still at the Court of Appeals, the Court of Appeal in Abuja has set aside the sack of Governor Abdullahi Sule of Nasarawa State by the State Election Petitions Tribunal. Delivering judgment, the 3-member panel led by Justice Uchechukwu Oyemenam held that the tribunal was legally bound to act on witness statement filed along with the petition, or front-loaded within 21 days as stipulated by law. The court held that no petition can lawfully be amended outside the 21 days allowed by law as wrongly done by the tribunal. Finally, from the Appellate Court, the Court of Appeal Abuja has affirmed the election of Uba Sani of the All Progressives Congress (APC) as governor of Kaduna State. Delivering judgment, a three-member panel held that the tribunal acted in error when it depended on inadmissible evidence to order the conduct of supplementary polls in 22 local government areas where the exercise was deemed inconclusive. The court stated that the key witness called by the PDP during the tribunal merely gave hearsay evidence as he wasn't present when the malpractices he alleged happened. Justice Hamza Muazu of the Federal Capital Territory High Court, Abuja, has granted the immediate past governor of the central bank, Mr. Godwin Emefiele, bail in the sum of 300 million naira and 2 shorties in like sum. In a ruling, Justice Muazu held that Mr. Emefiele should produce 2 shorties who must have landed property in the Maitama district of the FCT. Mr. Emefiele will deposit all his travel documents with the registrar of the court and must remain within the Abuja Municipal Council. He is expected to remain in Kuje Correctional Center pending when he meets the bail conditions.
And that's the program. If you missed any part of it, you can find it on past episodes on our YouTube channel. You can also give us a feedback via any of our social media platforms. Oh, and just before I go, here's one thing to think about. One of the many quotes from Lord Denning, the foremost jurist. He said the law should be a shield for the oppressed, not a sword for the oppressor. Something to think about. I'm Millicent Walker. Thank you for watching.